Hi future lawyers, and today it's time for a little C-A-lebration. The list is finally out. Congratulations to everyone who just passed the California bar exam. The July 2025 list is finally out, and I just want to start by saying congratulations to everyone who made it to this point, whether you already passed or if you are planning your next attempt. The California bar exam is one of the hardest legal exams in the globe, and every time I see that list go live, I think of the courage it takes to even sit for it, especially for all the foreign-trained lawyers out there. You are building a bridge between legal systems, language, and cultures. That's huge. Welcome, colleagues, you've earned your place among California attorneys. And for those still on the journey, don't give up. Every name on that list represents years of effort and resilience. Your turn is coming, and when it does, it will be golden, just like the Golden Coast. As we celebrate the new members of our profession, I believe it is a good opportunity to go back to the foundation of the US legal system, the legal DNA that shapes almost every doctrine you see in the US: common law, equity, and statutory law. Whether you are a new attorney or still preparing for the bar, understanding how these three interact helps you see not only what the rules are, but where they come from. So first of all, what is common law? It is important to know that although common law originated in medieval England, it has evolved in the United States to fit our legal realities. At its core, common law is built on judicial decisions, precedents that evolve through time. Judges interpret and apply the law, and those interpretations become part of the legal system itself. It started in medieval England, where royal judges traveled across the country and developed uniform principles, which are called the common law, shared among all courts. That tradition crossed the Atlantic and became the foundation of American law. So, when we study common law, we are really talking about a system born from centuries of case-based reasoning, refined through experience and precedent. But here's something many people miss. Early English courts were actually divided into courts of law and courts of equity. Courts of law could grant only money damages, compensation for a wrong, or handle eviction actions, since they are related to a property right. The courts of equity, however, handled cases where money wasn't enough. They could order specific performance, injunctions, or rescission when fairness demanded. Over time, these two systems merged, especially in the United States, following reforms such as the Federal Rules of Civil Procedure, but the distinction still matters, both for lawyers and for the bar exam. For example, under the 7th Amendment to the U.S. Constitution, the right to a jury trial applies to actions at law, but not to actable claims. So, if you are suing for damages in a federal court for breach of contract, you can demand a jury. But if you are only asking the court to compel the other party to perform the contract, that's specific performance, an equitable remedy, and the case will be decided by a judge, not a jury. Even though law and equity are now heard in the same courts, the distinction shapes everything, from the type of remedy available, to the procedure to be used, to whether a jury will ever hear your case. That's why, when you write essays on remedies, contracts, or civil procedure, recognizing whether you are in law or equity completely changes your analysis. Thus, even today, we talk about legal remedies, money, versus equitable remedies, fairness-based orders. Now let's go back to what makes common law so unique, and honestly, so fascinating to study. First, there is the principle of stare decisis, which literally means to stand by what has been decided. Courts follow prior judicial decisions to keep the law consistent and predictable. So when a judge decides a new case today, they are not starting from scratch. They are standing on the shoulders of the cases that came before. Second, common law uses case-based reasoning. Judges look at how earlier courts handled similar facts, compare the reasoning, and then apply or distinguish those cases to reach a fair result. It is a little bit like building with bricks. Each decision connects to the next one, shaping doctrine piece by piece. And third, common law is all about flexibility. Because it's judge-made, the law can evolve organically through interpretation and adapt to social change. whether that's new technology, new values, or new kinds of disputes. That's what makes so different from civil law systems like those in Brazil or France, where written codes and statutes dominate. But also remember that there are statutory rules in common law. Over time, legislatures began to step in and codify many rules that used to come from judges. That's how we got statutory law, written laws enacted by Congress or state legislatures. But here's the key insight. In the US, statutes and common law coexist. Even when a state controls, courts still interpret using common law principles. Take criminal law, for example. Most crimes in California today are defined by statute, like the definition of murder from the penal code. But the meaning of those statutes, such as what counts as malicia fordo, comes from common law definitions, and those definitions were developed by judges centuries ago. To bring consistency across different states, legal scholars later drafted the Model Penal Code, a proposed framework that helped modernize and standardize criminal statutes throughout the US. It isn't law by itself, but many state legislatures, including California in part, borrow its concepts and language when writing or revising their criminal codes. In that sense, statutory law gives the written structure, the black letter rules, while common law provides the interpretive foundation that explains how those rules should be applied in real cases. Keep in mind that sometimes statutes are applied strictly as written when clear, but the legal tradition frequently requires looking to precedents and actable principles for further interpretation. That's why every bar exam question on criminal law or torts blends the two words, statutory structure plus common law reasoning. For foreign trained lawyers, this interaction between case law, equity, and statutes is often the hardest, most fascinating part of adapting to the US system. In civil law countries, we look to the code. In the US, we look to the cases interpreting that code. That's how legal reasoning is built in, through precedent, fairness, and legislation working together. If you want to go deeper into how common law, equity, and statutory law work across subjects, from contracts and torts to remedies in criminal law, you'll find full explanations, flowcharts, and examples in our Aureus bar prep materials. They are designed especially for foreign-trained lawyers and busy professionals preparing for the California bar exam. Click the link below to explore our materials and unlock this week's special offers. And again, congratulations to all the new California attorneys joining the profession. Welcome to the common law world, stay focused, and I'll see you in the next video.